Okay. Welcome, everybody. Thank you for joining us to this hate speech interdisciplinary approach international workshop. We are very happy to hold this event. We did hope to have it in person for the first time after a very, very long intermission of these kind of events, but unfortunately, due to current circumstances, we're back to Zoom events, and we do hope that it's going to be a good one. We know it's going to be a great one, and it's going to be very interesting. And I want to ask Professor Salzberger to open the workshop.
Thank you very much, Ido, and welcome to this very important workshop on hate speech. The 21st century has seen the most rapid changes in life ever. The technological revolution is characterized by unprecedented pace of change or progress, if maybe too much progress, which can be reflected by the speed of the chip. I'm saying too much progress because such pace does not enable us humans to think about these changes and to adapt properly. I think that this is the main explanation for democratic deterioration, which we are witnessing in the last decades. And freedom of speech is another prime example. The technological revolution changes the old balances between freedom of speech and other rights and protected values. The great philosophers who created the modern approach to freedom of speech, John Stuart Mill, for example, would probably have turned in their grave had they known what was decided on behalf of freedom of speech by many decision makers, for example, by the American Supreme Court. And I think the two main or most significant fields in this regard are fake truth and hate speech. And I'm delighted that this workshop is dedicated to a thorough discussion of the latter. When I say that technology affects the old balances, I mean that in the context of hate speech, which is probably true also for fake news. Today, words spread around much more broadly and rapidly than in the past. And thus their potential to create real harm, including physical one, is much greater. So the aim of this workshop is exactly this, to revisit this phenomenon of hate speech, to assess whether the current law is well suited to deal with it, and maybe to recommend some reforms in the law. This workshop includes jurists, linguists, sociologists, gender study experts from various countries, including the UK, the Netherlands, Germany, and Israel. It is conducted in cooperation with the Freie University in Berlin and the Berlin Institute of Technology, and we are thankful for this cooperation. And it owes its materialization to a generous grant from the Minerva Foundation. This 3-day workshop is only one half of the project, and we hope that the second half, as Ido said before, will be conducted in person and in Berlin. And this is a workshop, not a conference, so we expect real deliberations and interesting interactions and revisiting your papers following this workshop. The Minerva Center for the Rule of Law that hosts this workshop was established almost 10 years ago, and its aim is to study the rule of law under extreme condition. And when we say extreme condition, we talk about belligerencies, wars, disaster, man-made, nature-made, pandemics. We were very, very instrumental in the last 2 years in the context of the Corona crisis. But we are also shifting in the last few years to deal with the extreme conditions of the rule of law, which are created without external extreme conditions. What I talked about, deterioration of democracy, and of course, And the topic of today is much in the focus of our center. So welcome to the Minerva Center. Have a great workshop. I want to thank Ido Rosenzweig and Michal Ben-Gal for a wonderful organization. And we are expecting to hear interesting insights and discussion. I welcome you all. Thanks.
Thank you, Eli. So right before we start, I'm going to set the ground rules for how we operate in this workshop. Each presentation is going to have approximately 70-minute time for presentation and discussion. The speaker will have 25 minutes to present their paper, which is the current draft of their work. As we've mentioned, this is part one. We look forward for actually comments that will promote the work of the paper, will promote the work of the researcher. And following those 25 minutes of presentation, we're going to have about 45 minutes of discussion. Discussion is from the participants of the workshop, but we also will welcome questions and comments from the audience through the Q&A feature. Each presentation, each session is going to have a moderator, a chair. That chair will present the speaker and will be in charge with moderating the Q&A and also provide their own input if they find it relevant and as well. So I think it's a good time to start. And our first chair is Professor Gad Barzilai from the University of Haifa and the Minerva Center. Gadi, the floor is yours to present Elena.
I just said that unfortunately, I've not seen the bio, of the first presenter. So would you be kind enough, Ido, to do it for me, and then I will take the moderation.
No problem at all. So let me introduce Elena. Elena Abroussi is a lecturer in the Law and Brunel University of London. Her research focuses on regional human rights system, digital regulation, and the impact of new technologies on human rights. She served as a policy advisor on digital regulation at the UK Department of Digital Culture, Media and Sport, and she was a postdoc fellow at the Human Rights Big Data and Technology Project at the University of Essex. She has been working with the UN Office of the High Commission of Human Rights and UNESCO on online disinformation and supported the implementation of the UN Plan of Action on Hate Speech in relation to online hate speech. Elena has a PhD in law from the University of Nottingham and an interdisciplinary background in politics with degrees from University of Pisa, University of Florence, Santa Ana School of Advanced Studies in Pisa, and Sciences Po in Paris. Thank you.
You're very welcome, Elena. Please go ahead.
Thank you very much. Thank you very much, Ido, and all the organizers of this workshop for inviting me and giving me the possibility to present my paper. I really look forward for the comments and feedback on this first draft. And this is really like the first time I put forward these ideas, and any kind of comment and feedback is very much welcome. I do have a brief slide presentation, so let me give a second to share my screen. My presentation and my paper title is A Local Response to a Global Phenomenon, the Role of National, Regional, International Human Rights Institutions in Supporting Social Media Companies Tackling Online Hate Speech. And just to give you a little background, and Ido already has done a little bit with my bio, this really sits at the intersection of my two main research interests. I've been dealing in the last 10 years with regional human rights systems, being that's the focus of my PhD thesis. And also I've been working with national human rights institutions, both in Europe and in Africa. And then in the last 3 to 4 years, I moved a little bit the focus of my attention to digital regulation and human rights and technology. And so the presentation and my paper today is an attempt to reconcile these two words and identify which could be the role, increased role of regional assistance and national human rights institutions and all other plethora of organizations that are called local human rights institutions in dealing with one of the most pressing issue online, that is online hate speech. So the structure of my presentation will follow the structure of my paper. So first, I will also take the privilege of being the first one to speak in this workshop. So I will set a little bit the basis of what we're talking about when we talk about hate speech. What is a hate speech? Also because I do believe that, part of the problem, I'd say lots of the problem comes from the definition of hate speech and the fact that it's so difficult to understand what we're talking about. And so all the challenges around hate speech offline and all the challenges that are even increased when we move to the online space. Then I will briefly give an overview of what could be and what has been the contribution of these local human rights institutions so far to the debate on hate speech. And then I will draw 4 possible options for collaboration that are not actually mutually exclusive or alternative, but they are all 4 on the table that follow the life cycle of addressing online hate speech, and there are 4 possible ways for social media companies to engage with these local human rights institutions, and I will locate this within the framework of the UN Guiding Principles on Business and Human Rights. So to get started, the challenges of online hate speech. So we all agree that hate speech is a really harmful phenomenon. We all agree that hate speech should be dealt with. We all agree that it's something really bad. But the real problem that any scholar working on hate speech knows is that we don't have an international agreed definition of hate speech. So while we all agree that hate speech is something bad, we don't agree on what really hate speech is. And I report here the definition given by the UN Plan of Action on Hate Speech that very generally defines hate speech as any kind of communication and in speech, writing, or behavior that attacks or uses pejorative or discriminatory language with reference to a person, a group, on the basis of who they are, or in other words, based on their religion, ethnicity, nationality, race, color, descent, gender, or other identity factor. As we can clearly see, this is a very general definition. It's broad definition and is really good from a policy perspective. If we want to use this definition to include any kind of manifestation that could bring some hate and do something and have a basis for do something policy-wise against it, it may be good. What is not good is moving it from a legal perspective when we are using this as a basis for restricting or other fundamental rights, mainly freedom of expression. So since freedom of expression is such a cornerstone of a democratic society, such a big, important role in human rights, we need to have a little bit more clarity on what hate speech is if we want to use that as a basis for restricting this right. And indeed, we do have in international human rights law provisions that establish the possibility to restrict freedom of expression when hate speech arises. So we do have Article 20 of the ICCPR, the International Covenant on Civil and Political Rights, that prohibits incitement to hatred, discrimination, hostility, and violence. But there is no guidance, not much guidance on how to assess it and not over-restrict freedom of expression. And these very general definitions and lack of appropriate internationally recognized definition has led to lots of regional human rights courts and international courts to have to deal on a case-by-case basis and assess whether a specific manifestation of speech amounted to hate speech, and has led to very debated judgments. So to come into our help in this attempt to find find more clarity on what hate speech is legally, luckily in 2012, the Rabat Plan of Action was adopted. And for my presentation, the Rabat Plan of Action is a very crucial document for several reasons, not just for the contents that I will go in a bit, but also for the process that led to the Rabat Plan of Action. Differently from lots of UN-based documents, it wasn't the result of just a Geneva-based workshop or expert meeting, but it was the result of several locally carried out expert meetings all around the globe, recognizing the importance of the context, of the local elements in understanding what hate speech is, in understanding how we should deal with hate speech and how we should understand it. So it was the result of so many expert meetings carried out all around the globe with representation from local NGOs, local human rights institutions, and so many different actors from academia and civil societies, recognizing the contextual element. But this contextual element was also the key of the Rabat Plan of Action. The Rabat Plan of Action gave us a lot of explanation on gave us a lot of guidance on how to interpret words such as incitement or hatred, kind of like redirecting us to the Camden principles, and also distinguish between legal and illegal hate speech. So that hate speech that is illegal, so should be tackled from a legal perspective, and that hate speech that is legal, still harmful, still to be dealt with maybe from a policy perspective, but not from a legal perspective, and not that should not be considered as a basis for restriction of freedom of expression, for example. But what probably is the biggest contribution of the Rabat Plan of Action is providing a threshold test. A threshold test that is the first test for assessing the severity of a speech and understanding whether that amounts to this kind of illegal hate speech. And the 6 elements of this threshold test have context written and local elements written all over there. So those are the context, the speaker, the intent, the content and form, the extent of the speech act, and the likelihood and imminence of harm. So those are the things we need to look at to assess whether whatever piece of content, whatever speech is actually illegal hate speech. And we could clearly see that all of them requires a deep understanding of the historical, political, social, cultural elements surrounding the speech to be able to understand the context, who is the speaker, what's the intent, what's the content, so the language, the slang, whether certain expressions are just a joke or they're actually carrying a harmful meaning. Also the extent of the speech act, but also whether there is a real likelihood of that to cause any harm in the future. So the Rabat Plan of Action offered a very, very good step forward in understanding and how to deal with hate speech, and the threshold test definitely is so much helpful, yet is not a conclusive one, and is not a fit-for-all definition or test, in the sense that it requires a lot of elaboration and knowledge, and it still requires a case-by-case assessment to apply this test in any given situation. So the challenges are still there, but the Rabat Plan of Action definitely help us on the way, keeping the local and the context as the main terms of reference. Yet, if the challenges of flying hate speech were several, mainly dealing with the understanding and what hate speech is and defining it, when we move online, those challenges remain, but they are even increased by a new set of challenges. And I know that other colleagues in the workshop will deal with many of these elements, so I will not go too much in that now. And I know there are specific presentations on some of these parts. Where online hate speech definitely is more harmful, in the sense that the virality of the content that goes online increases the spread, so increases that likelihood of harm, as well as the extent of the speech, if we refer to the Rabat Plan of Action threshold. But also it increases the challenge given by the definition, because if there wasn't a definition, a legal definition for offline hate speech, we definitely don't have a definition when it comes to how social media companies understand hate speech. So they've been doing some great job in the last few years in adapting their definition of hate speech for what content is allowed on their platforms, but there is still a lot of work to do. And also there is a problem of reconciling the fact that they operate on a global scale, so they need a global definition for hate speech. But what we just said is that hate speech needs a strong contextual element. So how do we reconcile the need for a contextual and localized understanding of hate speech with the need of a global definition of hate speech for a global phenomenon that is online hate speech? Also, these definitions need to be operationalized, both in terms of the countries where the posts are coming from, but also in the sense of giving operationalized definition that can be used by an automated system. We know that due to the global scale of the phenomenon, most social media companies use automated systems for detecting hate speech online. So we need something that is more detailed than the definition that we provided before from the UN Plan of Action, something that an algorithm can understand and can actually put into practice. Then there are the content moderation challenges. What do we do when we identify hate speech? And there are several options: removal of the content, blocking the account, and so many things that they may threaten other fundamental rights. And lastly, the appeal procedures. Under international human rights law, everyone has access to an appeal procedures for wrongdoing and access to remedies. Companies are failing on that quite a lot. We appreciate the effort by Facebook, now Meta, to establish an oversight board in this direction, yet lots of criticisms have been moved against that due to the lack of independence, language knowledge, expertise, and geographical representation. So still lots is to be done to fully assess, to fully address the issue of ensuring appeal procedures and access to remedies. So within this context, what has been the contribution of local human rights bodies to hate speech? And with local human rights bodies here, I include a wide range of actors that work closer to the field than an international institution. So, and what all of them have in common is three things that are quite important for our discussion on hate speech. First of all, the knowledge of the context, so the knowledge of the language, the knowledge of the historical situation, political situation, and culture as well, that could affect hate speech in its understanding, could affect our assessment of whether a certain piece of content is hate speech or not. They also have a deep human rights expertise, so they are not just organization working in the field, but they are human rights organizations. So they are deeply expert, and also most of them are used to making this kind of very difficult call on how to balance competing rights. And they also are mostly independent. I would say all of them are independent. There are some questions on the independence of national human rights institutions, but there is an accreditation system under the Paris Principles. So the national human rights institutions I consider here are all considered independent as well. So independence, human rights expertise, and deep knowledge of the context. And all of them have been working on hate speech a lot, both offline and online, in different capacities, in different ways, but they all have shown deep interest and deep knowledge and coming up with new ways of dealing with hate speech and bringing hate speech closer to the needs of the community they serve. So within the United Nations, the biggest attention is to UN field missions that are deployed in several countries worldwide, mostly in conflict or post-conflict countries. And they have been also identified as by the UN Plan of Action on Hate Speech as key actors in implementing the plan on the field, because of their knowledge of the situation, because of the expertise, because of range of activities they carry out. They could really, they do serve a key role in raising awareness about hate speech, supporting the governments, the local governments in carrying out activities to prevent hate speech at the local level. And they've been also run regional activities with different other UN field missions, especially in the African region, to coming up with innovative ways of dealing with online hate speech following the UN Plan of Action. The UN Special Rapporteurs, we know that several rapporteurs have been dealing with hate speech, but what we can see there is that when they write reports at the general level on hate speech, and I'm talking about the UN Special Rapporteur on freedom of expression or minorities issues or racial discrimination, they are definitely contributing to the debate, but at a very general way. When they instead write reports as a country after a country mission is where we could actually see some real and meaningful, useful contribution to support the local authorities in how to deal with hate speech in the country. And I'm thinking in the report on Spain, where the Special Rapporteur on Minorities stated out loud that the Catalan minorities should be included as one of the protected groups for hate speech that normally is not included in the definition of hate speech adopted by Spain, but it should, because it's a new kind of group that is subject to hate speech. Regional human rights systems, and I don't go in depth on this, but there are lots of activities and initiatives within each of them. The Council of Europe has been dealt a lot with the issue. The European Court of Human Rights has developed a huge case law on the matter, helping us in understanding how to define hate speech and apply it. The Council of Europe has established an expert group on hate speech, on online hate speech, particularly to draft guidelines on how to understand and how to deal with hate speech in Europe, so co-locating everything in Europe. Within the Organization of American States, the Special Rapporteur on Freedom of Expression clearly stated how hate speech in the Americas has a different understanding and a different conception than internationally or in other regions, because it's a narrower category. Or in the African Union as well, we expect now in 2022 a new report on human rights and artificial intelligence, where there is a specific mandate for the Special Rapporteur to deal with online hate speech. So we expect a very closer look at hate speech within those regional systems. And level of national human rights institutions, hate speech is a big focus of their work. In 2020 in Qatar, the National Human Rights Institutions Coalition meets, so 118 national human rights institutions met in Doha to discuss the challenges of human rights online, and one session only was dedicated to hate speech. So there is a huge attention to the matter, and we see lots of big contribution from specific national human rights institutions, like the South African one that published a toolkit with a specific set of keywords that in the South African context are to be considered as a red flag for hate speech, that normally we would not consider as hate speech. And something similar has been done by the Zambian National Human Rights Institution, or in Mexico, where the Mexican migrants to the US were to be considered as a new group, vulnerable group, to be included in the definition of hate speech. So there is a lot of work going on at that level of local human rights institutions. And so the question is, of my third part and then my main contribution of my paper is, what could be the role moving forward in dealing with online hate speech? They clearly have a huge expertise. They clearly have been doing a lot on this. So how can we use their expertise, and how social media companies that are struggling with dealing with online hate speech can use their expertise to better address the issue? And we don't have to forget that tech and social media companies don't have to do this as just out of their goodwill, but they do this out of human rights legal obligations coming from the UN guiding principles on business human rights. Under the UNGPs, they do have obligations to respect human rights. So carrying out a due diligence, a human rights due diligence in their operations. And in Principle 18, it's clearly stated that in this due diligence, companies have a duty to consult all the possibly affected groups, but also all the relevant stakeholders, with an emphasis of different level of stakeholders. So I would here interpret this kind of obligation as an obligation upon social media companies to engage also with those local human rights institutions that are definitely relevant stakeholders, that definitely represents the interest of those affected groups that are the people who are subject to hate speech. And so how this partnership or engagement could manifest itself. And going through the life cycle of addressing online hate speech, I argue that there could be 4 different ways of engaging. First of all, improving definition. We said that definition is a big problem, and the definitions adopted by social media companies are not good enough. So what these social media companies could do is to get the expertise of local human rights institutions to inform the review of their definitions, both the general one that should be kept general, but most importantly, the operational definition. So the operational definition that is then contextualized in different countries that the social media have users in, but also that are given to these automated systems for the detection of hate speech. Flagging potential risky situation. That's something that the UN Plan of Action in a way already mentioned, and also is mentioned by the EU Code of Conduct on hate speech. So the possibility of establishing trusted reporters, or that are those local human rights institutions, in my recommendation, that could act as a trusted allies for social media companies to flag potential risky situation. Knowing that, for example, something new is coming out in the country, there may be some specific groups that are at risk of being targeted by hate speech, or there are specific words that should be considered as a red flag for hate speech to arise, or something along these lines. Then providing expert advice. Because, I mean, once we have reported a possible case of hate speech, then usually what social media companies do is to review this content, usually by a human reviewer. And in this process, so it's basically an assessing competing rights at that point, freedom of expression versus protection of the rights of others. And here is where local human rights institutions who are used to make this assessment could be definitely helpful and jump in and make this assessment that should not be left to social media companies. Also considering their deep knowledge of the context, of the language, and of human rights. And lastly, supporting appeal procedures and access to remedies. This is still this is very complex, and I don't really know what form they could take. Maybe something similar to the Facebook Oversight Board, but on a local basis, or something similar to what Article 19 suggests as a social media council. But definitely, I see here a huge possibility for these human rights institutions that are underfunded but full of experts who are able to make this delicate assessment and who are used to make them to help social media companies to be more human rights compliant in their operation and ultimately being able to address hate speech. So thank you very much, and I really look forward for your comments and feedback.
So thanks very much, Elena. It's a fascinating topic, and you presented it in a very engaging way. And so firstly, just to frame the paper before I would have some comments and also some suggestions how to make your paper publishable. In a journal, I would suppose. So firstly, I think that the context is a context of globalization. So actually your paper is dealing with how does hate speech affect different localities, and localities might be at the level of nation states, communities, minorities. And on the other end, how localities of hate speech are actually influencing global developments and global trajectories in our attempts to halt, to prevent, to sanction hate speech. So basically, I would argue that the general theoretical framework is what we call globalization, and you apply globalization on the whole issue of hate speech. Now, I think that also your effort is very important, because if we define hate speech, and momentarily I will talk about definitions of hate speech, but if we try to define hate speech only or mainly or predominantly at the local level, then we don't have a deontological sense of what hate speech is. Especially since, you know, wherever we go now, we are on social media. And wherever you go on social media, you would have debates and also some very severe and rigorous and even insulting expressions. So again, we need to find not only ontological, but also deontological, not only local, but also a global definition of what is hate speech, especially, by the way, since your main interest would be online expressions, and online expressions basically don't know boundaries. If I would post, an insulting expression on my Facebook, which is predominantly in English, basically everybody can read that, whether you are in Sweden, whether you are in Ghana, or Australia, or elsewhere. So I think that the effort should be not to say it's all about communities, because what might be seen as hate speech in Russia would not be considered to be an hate speech in England, but we have to try to find a deontological definition. Now, I think that you are offering a very important distinction between legal and unlawful hate speech, because unfortunately, not a few expressions of hate speech are legal. If I say that, I'm Jewish, so if you say Jews are ugly, I would be insulted, but it's certainly not a hate speech, which is unlawful. It's hate speech, but not hate speech which I would endorse to sanction through using disciplinary or criminal mechanisms. So I think that what you are offering, it's very important. Some hate speech, unfortunately, are legal. By the way, those kind of hate speech would be maybe unethical, but doesn't mean that unethical or insulting expressions are unlawful. So your distinction between legal, might be unethical expressions and unlawful expression, this would be, a very important distinction. Now, I would like, however, to offer a definition following, obviously, your very engaging lecture, what would be unlawful hate speech. This would be a speech which constitutes a tangible danger or a tangible and immediate danger to public safety through inflaming violence. So I repeat my tentative attempt to define unlawful hate speech, which is in distinction from a lawful hate speech, which again might be unethical and insulting, but it's still legal. And I would offer the following definition, that unlawful hate speech would be a speech which tangibly constitutes clear and present danger to public safety through inflaming violence. And I think that we have to find a rather narrow definition. Otherwise, we are really imposing sanctions on freedom of expression, freedom of politics, and then you are actually playing into different kind of political systems that may use terminology of hate speech in order to impose legal censorship, which is very dangerous on freedom of expression. Now, should be said, I offer the distinction between unlawful hate speech and a lawful hate speech. So if somebody is insulting me, I wouldn't support a legal censorship. Notwithstanding, I may enjoy civil remedies. You know, if you say Gad Barzilai is bad, I may use my legal right to sue for slander. So I think that we need a better definition which make distinctions between unlawful hate speech and the lawful hate speech, and what are the legal sanctions which might be available at the civil level, not criminal level, regarding unlawful yet legal hate speech. So I think that you have a lot of ground to work on with different distinctions and different, obviously, legal trajectories and legal ramifications. I'm not as much concerned about algorithms. Actually, my elder son is doing artificial intelligence, mainly through mathematics, and he argues that basically we can have even better results than the human brains. But I should say that in your paper, it's not the main issue. I mean, once you have a good definition, most probably you can build an algorithm which will do the job for you or for the court, at least under certain circumstances. Now, at the end of my very short comment, because again, it's a very engaging paper and topic and lecture, and we can talk about it for hours, I would like to end up, before opening it to the questions and comments, 2 suggestions regarding your paper, how to make it publishable. I mean, it might be publishable as it stands now, but maybe you would benefit from 2 type of advice. Firstly, I think that you are very ambitious in your paper, and you are trying to capture a lot of variables in one paper, which is often very dangerous if you would like to publish a paper in a good journal, because often journals are looking for a specific argument which is well focused and the theoretical contribution is well defined. So the broader the paper is, the less probability of publishing it in a good journal. And I think that in a way you have 2 papers in one lecture. I think that one paper would be the definitional paper. what is hate speech, what kind of unlawful hate speech we do have in international law, with trajectories and ramifications on domestic law. This is one paper which is very important and very interesting. And the other paper should be, in a way, a more empirical paper, which is looking at a few case studies. Right. So there is the whole methodology of case selection, which we are not going to deal now. So I would suggest in a second paper to select a few case studies. You mentioned the Catalans, and to look into it through the perspective of how NGOs at the international level have changed the local level of socio-legal attempts to halt, to confine, and to limit hate speech. So I think that basically, in a way, there is a tension also in your lecture between those two types, because if you only mention the Catalans and a few other examples, at the level of look into it, it's an interesting example. The paper is not really goes into the whole interesting details of the specific case study. So I would differentiate between a more theoretical paper, which is also looking mainly at international law, and the whole context which I offer to look into of globalization, and the other paper might be more empirical, referring specifically to several case studies. But Elena, thanks very much. It's really, really, really interesting, a very good kickoff to our workshop. And now let's open it for comments, debates. So if you just can raise your hands, and you should unmute yourself once you are asking a question. So go ahead.
I see Amnon is raising his hand.
Amnon, please.
Hi, thank you. Indeed, quite fascinating. I have to apologize. I won't be able to attend the whole day today because I'm off teaching very soon. I want to introduce the third paper that you have in your paper, and that is the institutional/procedural paper. So I think part of what interests you is who defines what God just mentioned, and then who gets to decide the following procedures. Because I think your point about localization that some hate speech, so language in general is local to the extent that local context matters. And there you might want to consult the wonderful work of Robert Post on what counts as an insult. So Robert Post, I don't know if you've had a chance to read him, but there's a whole line of US case law about insulting, defaming public figures in the United States. And it's an issue. Why? Because public figures actually what they have is their reputation. For them it was more their reputation, but they get less protection in the United States for their reputation. So the question is why? Does this make sense? And Robert says, well, what insults you because it puts you in a bad position vis-a-vis the values of the local community. Which because speech in the United States is there to generate the values, because it's so heterogeneous and nobody agrees on anything, and so you have to keep speech, the public forum as open as possible to contesting values, and therefore to insults, which is why you have the definition you have in the United States. So I think you can build on that, the relationship between community and what counts as hate, and then and then therefore how speech should be regulated. I think your point is really interesting. But Gadi talked about that. So I just wanted to add this theoretical point here, and then continue to the institutional part. You seem to suggest that and here I slightly disagree. You seem to suggest that red flags are important, and you end there. You say, well, if there is a red flag, then somebody will figure out what to do with the red flag. And then you suggest also that international organizations, NGOs or something, are better situated to address those issues. And I wonder, I really do, because if the experience of the platforms is anything we can learn from, then they're having a really difficult time. Algorithms not understanding. They're having a really difficult time dealing with red flags. Why? Because it depends on the context. You can say, I really think the word so-and-so is atrocious, it should never be mentioned. So once you use the word, it's going to get picked up by the red flags. And then what do you do? How do you, and then some human eye should look at this, but then the volume comes in. And it's too, you can't deal with the volume of it. And then the algorithm sometimes generates really weird results. No, I mean, these are known that somebody who advertised onions got kicked out because it was considered by, I think it was Facebook, somebody sexual or something, because onions remind the algorithm of sexual of female breasts, something like that. So you know, end up with those, and then comes the institutional question: How do you appeal? To which body do you appeal? And how did? So there is an alternative here, and I think it addresses in part what Gadi was also thinking in terms of the remedies, but I think there's an alternative. The alternative is what we call, and this hasn't been, it's what we call quarantine. So you don't delete the speech necessarily. You flag it as potentially dangerous and you quarantine it in a certain way. Because what matters about speech is the viral nature of it. So rather than dealing with the speech itself, I think a much more interesting venue to consider is limiting its viral distribution. And by viral, I mean the number and also the time. Sometimes it's enough that you delay by a week or something, especially out there, but you delay the distribution for a week, or you allow comments, or you allow input, or you allow something. And then you contain it, because the combination of a lot of people very fast. That is what we should worry about in terms of hate speech. If God is right, if we distinguish between dangerous hate speech, that is speech that can actually cause disruption and actual violence, to speech we don't like because it's immoral. But nonetheless, we should somehow tolerate, or we should distinguish the remedies in terms of criminal versus civil versus administrative, etc. I want to conclude. So you can develop space paper there. You can go there and say, I have a potential there. And then the due process really matters. Who gets to file a complaint? Who has to defend? So Facebook is very bad in the due process point, because it's unclear who has to defend the speech. So suppose because sometimes they don't even tell, they don't give a right to contest and say the publisher sometimes has no rights at all. And then can you appeal? So there has to be. On the other hand, you don't want to open the entire process because it's going to be so taxing in terms of time and resources. So there has to be a better way of dealing with it, which itself should be transparent. So I think one of the most interesting contributions that you can make is whatever we decide, the worst scenario we can end with is that the arguments about what counts as hate speech are left concealed. Because if we can deal with hate speech successfully, it is why is it hate speech and why is not hate speech? Even that very conversation, I think is one of the main contributions that come out of it, because then it takes this thing out of what hate speech is, and it allows us to build and learn each other, and then we can see how it's dealt in Germany versus let's say the Netherlands, they have a crazy decision about the politician that they said that was hate speech what he said about the Moroccans, which would never happen in the United States. That would be considered unconstitutional. That's what they did to the Dutch politician. In any event, we can learn comparative conversation, which is your point about the transnational dimension.
Okay. Thanks very much, Professor Eichmann. And maybe before we are moving to Martin, I see that Martin would like to make comments. I will ask Elena to respond briefly to Amnon, and then we can continue our Q&A. Please, Elena.
Yes. Thank you very much, Gad. And also thank you for your comments. And I do agree with everything you said, especially the fact that I maybe put too much in my paper, but that was in a way made on purpose because I want to stimulate more discussion. And since this was a workshop, I wanted to put more things on the table to be able to see where the conversation was steering. Thank you very much for your suggestion of splitting into different papers. And I honestly doing another section of discussion on algorithms, to what extent we can trust algorithms with the definition. The definition should be really good and precise, I believe, to trust an algorithm to do our job better than you. But I think that's a different conversation. In relation to Amnon's comment, thank you very much for pointing out about like incitement. I will definitely look at that. So on the red flags, yes, perfectly right. And I think my proposals like for collaboration and red flag part was in a way of like taking the good from the UN of Action Hate Speech guideline for implementation. That's the UN forward, where this trusted reporters were sketched out as civility, as well as what the EU Code of Conduct suggests. And just to make it clear that here I'm not talking about NGOs. NGOs is what right now is considered as like trusted reporters. But of course, with NGOs, there are a lot of sets of problems. If we basically just like move the responsibility from platforms to NGOs. Here I'm talking about either human rights systems or national human rights institutions. So they do have a higher degree of independence. I mean, NGOs are really acting human rights things. When we are talking about national human rights institutions, regional human rights institutions, we often talk about judges, people who are expert in policy and in politics, and we do recognize judges of the European Court of Human Rights as positive and binding. So why shouldn't we trust the same people to make assessment on consideration? That's the rationale behind giving those organizations higher powers. But it's true that of course there is a problem of appeal. So if they make the decision, then should we appeal to them rather than to the platform? Yes, and that's something I definitely need to look into. The part of that. When it comes to your suggestions on the alternative ways of dealing with what do we want that is speech. Yes, you're right. Like stopping the virality or delaying the content is a great way. I don't go into the depth of content moderation initiatives because I thought it was something even too much to include in my paper, but of course, if I split into I definitely bring this in as part of the equation. And the transparency and due process, transparency is really the key for anyone working with rights, technology, and content moderation. We always after companies to be transparent, but probably transparency here also on this set and on how we assess if something is or is not content is hate speech matters. Just one thing on the red flag of the words, and then I stop. I think like the value of that is Because right now, what happens, for example, with the Facebook community guideline, they say that hate speech is comparing a group or an individual to an insect. So every time an automated system finds that word fits with whatever word or insect with a group or a person, then it flag it as possible hate speech, and then it goes to a human reviewer. What my proposal is that this flagging system would work with these keywords identified by local human rights institutions as possible conveyor of hate speech. So it doesn't mean that we are removing or like the speech altogether, as that red flag words are identified, but then we as since it's already happening now, random words that social media companies decided are flags for hate speech. I'm just saying maybe we should revise this red flag words and who can help social media companies to revise those words are human rights institutions.
Thanks very much. Thanks very much. Please go ahead.
Thank you very much, Gad, and thank you, Elena, for your contribution. I just want to make three short remarks, keep it short. One is I really like your paper as it focuses on this context dimension, because I just was 2 months ago I was in West Africa for a few weeks on a project on hate speech and fighting violence, and we made very similar arguments like you that because they have a lot of contextual problems there. For example, local language cultures which are not covered at all by Facebook and their content moderation mechanisms. So there's a lot of potential in your paper, and I like that very much. Second remark is that I would go with God on his advice to focus your paper. My personal preference would go for the second part of your paper, because I'm an empirical social scientist, and I like this analysis of these institutions, and I think there would be a lot of potential in it. For example, what you outlined in your presentation a bit more in detail than I found in the paper is the potential of these institutions. So what can they contribute? That could be a theoretical chapter in your paper and would make the second part stronger. I would like that. And then the third remark is a question, and that is you focused a lot on independence, for example, transparency, but what I missed a little bit, surprise. What was surprise for me is the dimension of political legitimization. Is that really your argument that you say it would be enough for companies to cooperate and negotiate hate definitions with human rights institutions, or was it just the theoretical focus paper? Because for me, political debate and political legitimization of definitions and actions based on these definitions would be necessary as well. Thank you.
Thank you, Martin. Elena, please.
Thank you very much. Comments all taken on the paper and advice. On the political legislation, I honestly didn't. I know it's a big that is missing from the paper. I didn't have the time and space to go into that. Although I'm a human rights lawyer, so as such, I do think that. It's better to come from recognized independent human rights institutions as advised how to advise definitions rather than the social media companies internally. So I would see that anyway as a step forward, but probably in my revised paper I would definitely add point on political legislation. Thank you very much.
Thanks. Asaf, please.
Yes. Hi. Good morning, everyone, and Elena. Thank you for this very interesting and knowledgeable paper. what I wanted to express is, I guess, a concern from a different angle, and perhaps something that, some of the things that Amnon said, address my point, but nevertheless, I would like to refer the question to you. I think that it's a very interesting and original and basically a good idea to avail ourselves of local and regional NGOs in combating hate speech, and in defining what is hate speech in the local context. But my concern is that perhaps given the cancel culture and everything that's going on in this regard, aren't you concerned of certain bias that local NGOs would have due to a radical progressive agenda that might entail, I would say, harsh strict definitions of hate speech that may, cause prejudice and more restrictions on freedom of expression that we like to see. Because if we trust local NGOs, and let's say I'm trying to think of what's going on in Germany. As an Israeli, I know very little of, if anything at all, of what's going on in Germany. And if a local NGO would say, this or that is considered hate here, and it's offensive, and it's something that we can't tolerate, and so as an Israeli, I would have I don't have a very good position to judge whether it's correct or not, and so I don't know. It's just placing maybe too much power in the hands of people that come very good intentions, sometimes with an agenda that doesn't necessarily correspond with the general public, let's say, and so on. So I don't know. I would love to hear your opinion on that.
Thanks very much. Elena, please.
Yeah, just briefly. I think probably one is, and my fault because I didn't make it clear, and it should be clear in the paper definitely. Time. Every time I talk about human rights institutions, I'm not talking about non-governmental organizations. So I'm not talking about NGOs, which may have a more, in a way, biased agenda or a specific agenda in mind. I'm always talking about national human rights institutions, which are institutions that are established by the state, but then become independent. So they should be the watchdog of human rights in the country, but they are not an NGO. They are not externally funded. They are public bodies. And I'm also talking about human rights systems that again they're not NGOs. So of course they could be biased, and there are lots of research on how even the UN is biased, even all any kind of even state is biased way put forward an agenda. But I do not see that. Of course, something I should make clear as accessibility and danger to maybe put in place some procedural fix to ensure this doesn't happen. But I'm trusting those organizations because they should be those independent organizations, not NGOs. They are, and that's why I make the distinction between what is now the trusted reporters that are NGOs with something that are more independent institutionalized human rights institutions. That we already trust them with our human rights case when we bring a case for their attention.
Thanks very much, Sonia.
Yes, thank you. And also thank you, Elena, for your interesting paper and the interesting presentation. I just had a very brief comment when I was reading your draft paper. I noticed that when you were talking about the challenges of tackling hate speech in the online environment, you were focusing on changes regarding the distribution of hate speech, the scope and dissemination. And I was thinking that for example, the literature in the field of communication research, there are also some arguments made that the rise of social media especially had an influence on the content side of hate speech. So I thought that this would maybe even strengthen your paper if you include this idea. How, for example, the speed of online discussion is changing the tone, or is pushing people to be more extreme because otherwise they have the feeling that they are not noticed or that they are not heard. So there are these kind of arguments in the literature. And so I thought maybe this could help your arguments to make it stronger. And also, I don't know, maybe when you were discussing how those institutions could help flagging hate, for example, this could maybe even be another. You made like four points, I think, in your paper, right? Maybe this could this content idea or this content-wise changes could maybe even be fifth category. I don't know. Yeah.
What I suggest, because we have about 8 minutes, so let's take Carolina, a comment question and a lead comment question, and then and Nasir also Eva. So let's take 2 questions and 2 questions. Okay. So please go ahead, Carolina.
Thank you very much. I'll try to be brief. Thank you, Elena, for your presentation. And I agree that it was very broad and triggered a lot of discussion. Even if I've had the publications, it will have to be narrowed down. I wanted to refer to something that was mentioned earlier by a couple of people and yourself as well about online moderation and how AI might help with this. I'm actually working on a project that will deal with it at a later stage, a project called Decoding Anti-Semitism. Actually, one of my project colleagues, Laura Ascon, is here as well. And we are basically doing a vast amount of qualitative research on online hate speech comments, in this case, anti-Semitic hate speech. So that later our experts can train artificial intelligence to recognize it better, and slightly in a more nuanced way than it is now, hopefully. And we do take into account localization. We have 3 teams, UK, German, France. So we do look at those nuances, even between fairly, not very distant cultures, European cultures. But still we take that into account, and we have our specialists from the field of history, philosophy, conspiracy theories, political sciences, and linguists like myself. But we do not have at this stage what you've been talking about, the point of view of for example, human rights lawyers like yourself, or other institutions from perhaps that field. So I was wondering if you would think that we could benefit from this, and perhaps should it be at the early stage or later on? So that's my hopefully question. Thank you.
Thanks very much, Carolina. Please. Professor Salzberger, please.
Two comments questions. One got to the content of hate speech, and the second got to the procedure. With regard to the content, I noticed that all your discussion of substance definition of hate speech was related to discrimination groups, and I wonder whether hate speech is not much broader. That you can actually target the person not because of his race, ethnicity, and how can we address this? So how can we incorporate hate speech is not connect discrimination groups? The second, the procedural issue, I think it's a broader question. we're talking here about this social media platforms, which are international organizations, and this is connected to a much broader problem. Who rules us? Our governments we elected, or meta companies, international global companies that set their own issues. And I think that one of the things that can be improved with regard to the procedure is a much more general, a more draconic and dramatic change with regard to the issue of what is the position of international mega companies within the municipal law, whether they should be decision makers or we should intervene and make the decision according to our values, constitution, rights, and tradition. And I think this is not only limited to hate speech, because maybe the change here should be a structural change with regard to governance, with regard to corporation law, which will have an impact, of course, positive impact on the phenomenon of hate speech. Thanks.
Thanks, Elisa. So last comment for today before Elena responds will be Eva. Please, Eva.
Thank you. Can you hear me all right?
Oh, yeah.
Yes. Okay, thank you. Well, thank you so much, Elena. I really enjoyed your paper, and thank you for the presentation. I have a couple of comments. I'll try to organize my thoughts as best as I can. I do think that the paper touches on two main things. So one, the definition, and second, models of governance. Whether that's better divided into papers, I'm not entirely sure, because I think in a way that could be a way to still have this as a whole, as presented as one story, but that depends also on how to then tweak it later on. So I do agree with that, not necessarily that it needs to be divided into two papers. And then I have a couple of more detailed comments, I guess. So one, you've mentioned, and I understood this more from the presentation rather than from the paper, so maybe that's something that could be strengthened. You mentioned that you really focus on the UN Rapid Action Plan of Action, not only because of the substance, but also because of the process of how we got there. And I think in the paper that perhaps be strengthened, because you do mention the importance of grassroots movements, and so I think that could perhaps be strengthened in the paper. Also, then linking it with another more detailed comment on the importance of these national human rights institutions. And so I think in a way that could be a link that could be established again with the importance of grassroots movements, similarly to how we gotten to adopt the UN Rapid Plan of Action. I think in a way there's also some discussion that could be presented as to whether actually the national human rights institutions are fully diverse and representative, because in a way, as we see also specifically in countries where of course there's fragile democratic institutions, if you only consider the sort of national institutions, there's a lot of diversity and representation that might not be there. So I just wonder how you would address this comment, and also linking it to the importance that you've established and addressed at the process of the Rapid Plan of Action. So that would be another comment, and then two more things. So on the essentially on the models of governance, I would really recommend one study produced by Alexander Brown of the Council of Europe, and it's really on models of governance for hate speech, where he really mapped in 200 pages, the pros and cons of having just flaggers by NGOs or by ombudspersons or some different stakeholders, pros and cons of different procedural options, and so I think also it touches very much on remuneration and independence. So how can we expand on these pitfalls? I think from the paper that would really benefit the paper if you delve a bit more on into this. If we do follow your suggested plan of action, there are of course pitfalls, and I guess if you could already expand and give us your view on how to address some of the pitfalls, this reading could be useful for forming that section maybe. And finally, on the UNGPs, so the United Nations Guiding Principles, I do also think that, so you've mentioned that you make a claim that basically the UNGPs, if I understand correctly, require collaboration with different stakeholders and civil society, and also if I understand correctly, human rights advocates in general. And I think if you could expand on that would be amazing, because it's not clear, I think for our general audience, how that extrapolation could be defended. But I think it's a really interesting one. I think it could benefit the paper as well if you expand a bit more on that argument. But overall, congratulations. I really enjoyed it. Thank you.
Thanks very much. So, Elena, we have a few minutes of response before we have to conclude. Please go ahead.
Thank you very much to everyone. Really good comment and feedback. Sonia, definitely really interested in including some of that in my paper. If you could direct to any literature that I should look at, that would be really great. And I think definitely benefit paper. Carolina, I think what you're doing is amazing. I really look forward to hear more about your project. And it's great that you're also looking really much at localization, even within the European context that we think it's all the same, but it's not. And each country has its own way. It really supports my idea of the context elements so important. And I think especially in those countries, human rights institutions are really strong. So I would say that you would benefit from something like engagement with national human rights institutions, or maybe just considering how much the Council of Europe has been working on these issues, maybe even just with the Council of Europe and with working on hate speech, that would be probably beneficial for your project. I'm also happy to have a look if you think it's needed. Professor Salzberger, I think that hate speech in groups, and the problem with the definition is also that. I think the challenge of coming up with an agreed definition and also localize those definitions, because in some countries hate speech does not affect groups, but affect individuals as individuals. So I think that's even making more complex the issue of defining what hate speech is, and going back to what suggested at the beginning of the importance of keeping a global definition. It's a global phenomenon, and so ontological. I think we need to have this, and I only briefly touch on that in my paper. This kind of not conflict, but the dichotomy between universality and relativism in a way. So that we need a global understanding of what hate speech is to give us guidance on the fact that hate speech is something we need to address, and what in general terms is hate speech. But then we need this relative universality in a way that when if we want to make happen, we want to really address hate speech in the specific circumstances, we need more contextualized understanding of speech that sometimes move away from groups and kind of more individuals and the trees that make us threatened by hate speech. and UNLawful tells us really important question, the digital governance board, and I think this question is bigger than my presentation, my experience as well, deals with the role of these companies in the global world, and I think international law has been used so far as a way to kind of limit their powers because of their global and scale of work, but we see now it's more antitrust laws being used to stop them and to influence their values. So I think there's a lot of philosophical debate on what are the values that this company should forward, and one of the users, one of their headquarters of the company they operate in. So really important questions that definitely need an answer, but I think my paper doesn't offer much in this, but I try to do my best in the next draft. Eva, thank you very much. Really important points, all of them. I'll take them all on board for my next draft. And thank you very much for pointing out something that was not clear or should increase and expand more. And I will definitely that publication from the Alex and Brown sounds really relevant to my work. Thank you very much.
So we end up this session with an agreement, a consent that really Elena offers us very engaging, elaborate paper and lecture. And I think the discussion was very fruitful. At least I felt that it was very fruitful. So thanks very much, and I'd like again to acknowledge Ido and Michal for organizing this workshop. And now Ido, could you please guide us about how we continue, what is the next session and when?
We're going to take a 5 minutes break between the sessions, and then the next presentation is by Tigan, and I will be moderating that talk. Okay, so let's take a 5 minutes break.